Provision for pre-hearing panels, right. Pre-hearing panels are replacing business meetings. Okay? Business meetings will no longer exist. The kind of decision that pre-hearings panels make is deeming relevant persons. I'll come back to exactly what that means and what the thoughts are on that in a minute or two, and excusing the child and or relevant persons. The third one in there that I probably should have put on but didn't is ascertaining whether or not the child is likely to go to secure. And the reason you would have a pre-hearing to discuss that is so that you could get legal representation at the actual hearing. So they're the kind of decisions that pre-hearing panels make, and we've put provisions, again, what documentation needs to be sent out, who gets it, who can come to the hearing. I mean, the big difference with pre-hearing panels and business meetings is that the family are informed and have a right to be there. They don't have an obligation to be there, so it's slightly different to a hearing, but they do have a right to be there if they wish. This deeming of relevant persons, this is something that's been wrested from the hands of the reporter and placed into your hands. The reporter is told who is a relevant person in the Act, and that's basically birth parents or anybody with parental control, parental rights and responsibilities. So that would be adoptive parents. All fathers are relevant persons, married, unmarried, or whatever. So all fathers are relevant. Anybody else, the reporter has got to either call a pre-hearing panel, or if there's not time, it has to be decided at the beginning of the hearing. So somebody who might be a relevant person, they can ask. So if Granny's looking after this child 4 days a week, doing a lot for the child and all this, she might actually go to the reporter and say, actually, I think I should be at that hearing as well. Or the child might go to the reporter and say, actually, my granny should be there. Or the reporter themselves, having looked at the social background report, can say, I think granny should be there. In any of those instances, a pre-hearing panel will be called, and you, the tribunal members, will decide who's a relevant person. It's all about significant involvement in the upbringing of the child. And that's been defined as making significant decisions in the child's life. So it's not granny who looks after the child 3 days a week, even if the child sleeps with granny 3 days a week. Granny's got to be involved in decisions as to things like what school does the child go to, when's the doctor called, has the child had inoculations, JAGs and things. It's significant decisions. But I think what's important about this one is that it will be a decision you need to make that is not necessarily in the best interest of the child. Because this person who has a significant involvement in the child's upbringing might be a paedophile. It could be anybody. But if his mum's by the inn and he's helping mum make significant decisions about that child, even if the child hates the sight of him, he's a relevant person. One thing I will say is that provisions have been made in this Act now and the rules that when the child is excused, either at a pre-hearing or at the start of another hearing, that excusal will only last for as long as that hearing's current. So it would last, if you defer the decision and there's a continued hearing, then the child is still excused. You make a decision. If it goes for an appeal, the child is still excused. But once any appeals and all the rest are over, for the next review, if the child's not going to be there, there has to be another pre-hearing panel. So you won't get this situation where a child's excused at 2 and you don't see him again till they're 6. All right, part 13, I'm lucky for some. So this is about appointment of safeguarders. And a couple of changes in there for you. We've put in some strict timescales. We were getting, there were reports of safeguard reports taking as long as 3 months to arrive. I think that was exceptional. So what is now in the Act? Are you all aware that Children's First now run the Safeguarders Panel? Right, yeah. So they've got the National Safeguarders Panel. You appoint a safeguarder at a hearing. The reporter has got 7 days in which to get notice to Children First and for Children First to appoint a safeguarder. As soon as that safeguarder is appointed, that safeguarder has then got 35 days to get a report to you into a hearing. 35 days is still quite a long time, and it's meant to be a backstop figure. You know, one would hope they get it there sooner, but within 35 days they must have some sort of a report ready for the hearing. And that, what I've got up there is I've got interim reports, and that's one of the options we've given them, so that if it is a complex case or they are having difficulty getting hold of someone, but they have an idea that they might still be able to, then they can issue you with an interim report. But that interim report has still got to come to a hearing, and the hearing has got to review the interim report and then make a decision. Well, does this interim report give us sufficient information to make a decision, in which case you have the right to do so, or do you, as a panel, say, okay, we've seen your interim report, we can see why you need more time, you can have another period of up to 35 days. Now, you don't have to give them 35 days, but you can't give them more than 35 days. So it just stops safeguarders reports just trailing off into the distance. Okay, moving on from safeguarders, part 14, general procedure at children's hearings. This is duties of the panel chair, or some of the duties of the panel chair, checking that they've received reports, checking the child's views are represented, introductions, purpose of the hearing, all that type of thing. So they're all in the rules, but they will all be in the step-by-step. Same for grounds hearings, procedures there, putting of grounds, procedure where they're not accepted and understood, review of relevant person status. So we've talked about that one. Let's have a look at the other one. Putting grounds, the new Act is written slightly differently to the current Act. What you would call a ground for referral under the new Act is just called a Section 67 ground. Section 67 is just the part of the Act it's in. So at the top of the document you would have the Section 67 ground. Underneath, currently, you would have statement of facts. Is that what everybody calls it? Yeah, statement of fact. They're no longer called the statement of facts. That's called, the whole thing is called the statement of grounds. What the Act says, strictly speaking, and with a strict literal interpretation, and bear in mind lawyers will take strict literal interpretations, is that all the child and relevant person has to do is accept the Section 67 ground. They don't have to accept the statement of facts. We'd written into the rules something that said that if they don't accept something in the statement of the grounds that supports the Section 67 ground, then you could send it to the sheriff for proof. But unfortunately, when we did one of the road tests, we proved to ourselves that even that's not sufficient. You can get the situation we ended up with, I mean, it was a fictitious case, but we made up this case of a young lad. He was self-harming, he was taking drugs, he was carrying a knife, he'd been involved in a stabbing. I think that'll do. I mean, there was more. He came along to the role-played hearing, and he denied everything except the self-harming. Now, the Section 67 ground that child was called to the hearing for was he was a danger to himself or others. By accepting that he was self-harming, he was accepting he was a danger to himself. But your hands in the hearing would have been tied because you denied everything else. Sorry, breach of duties by a local authority. I want to mention that because that's a significant change. That's been changed. This is the local authority accountability bit that was brought in under the Antisocial Behaviour Act. This has been changed quite significantly in as much as, remember, for this to kick in at the moment, you've got to recognise that there's not been action and then ask for an early review, and then the local authority bit can kick in. That requirement's gone for a start off. So at any hearing where the local authority has a duty and you recognise that duty is not being complied with, you can start the local authority accountability thing. More procedures. This is procedures for hearings again with both grounds and a review hearing. And then there's procedures at other hearings. 2nd and 8th working day hearings, they stay in place. Advice hearings, they stay in place. And a further ICSO. I don't know how familiar people are with ICSOs or what ICSOs mean. Under the new Act, warrants basically go. There is a warrant to secure attendance at a hearing. That stays. All the other warrants go. And what you have in their place is this thing, and it's an interim compulsory supervision order. Supervision requirements go. Supervision requirements are called compulsory supervision orders. Okay? And these things that are effectively warrants are called interim compulsory supervision orders. The nice thing about them is that they are a 22-day supervision requirement, basically. This further ICSO hearing is just, these last 22 days, exactly the same as warrants. I mean, they're warrants by any other name, but they're slightly more flexible warrants. And second and eighth working day hearings, they're the same, and child protection orders are basically the same as well. So that's 17, 18 general issues, right? Procedure for a warrant to secure attendance, procedure for advice from the national convener. This is, you're probably aware that if you need advice and you can't get advice from any other source, then you can defer your decision and seek advice from the national convener. A couple of things that come into it. Non-disclosure by writer of report. At the moment, what happens if the social worker knows something that thinks you should know as panel members, and one example I've used in the past is mum's got a terminal illness. Mum's going to be dead within a year, possibly, probably. You know. She hasn't told the child yet and isn't ready to tell the child. Obviously, that would have a significant harm to the child if that was suddenly blurted out in the hearing. So what the reporter currently does is that's deleted, effectively deleted from the child's copy of the report. But what more than often happens is, in fact, you all get a report that omits that, and you get a supplementary report with that piece of information. Whichever way around, it doesn't matter. But you get a piece of information that the child doesn't have. That decision is made by the reporter, and this is another one of the decisions that Parliament think you should be making, not the reporter. Now, the logistics of how you do this is what's difficult, but what is being said is if the reporter wants to make that decision, the reporter, obviously it has to be done up front. It can't be done after the reports have gone out. So the reporter makes that decision, but has to refer that decision to you at the beginning of the hearing. So you then have to decide, and what you have to decide is, will releasing that piece of information cause the child significant harm? Notifying decisions, all the normal stuff, the people have got to be notified of their rights and so on. Talks about information to be given to local authorities and others. One of the things that we have got written into the Act now, you're still going to have to say at the end of the hearing about rights for reviews and this type of thing, but the reporter's also going to have it on a sheet of paper and send it out to the family afterwards. So, because half of them don't hear what you're saying by the end of the hearing anyway. Secure accommodation. Same thing with secure is that you authorise secure. You don't insist on secure. The difference there is as at present you authorise secure, and it's down to the head of social work and the head of school if the child goes into secure. What's written into the new Act is that if the head of social work decides not to put the child into secure, then that's a done deed. But if the head of the school refuses to put the child into secure, the child or the social work department can appeal to a hearing. So that's what that review of authorisation is about. So very strange hearings where you said you want someone in secure, the head of secure has said, no, I don't want the child in secure. So it comes back, and you'd be asking him, well, why? Now, this hopefully the head of secure will have firm reasons for doing so, but at least it gives you a chance to find out why. Okay, miscellaneous, that's to do with expenses and service of documents. So again, really nothing. I mean, it's the expenses that you get, so it's something to do with you in as much as it's your expenses. What I do want to say is this: it's a complex document, it's a long document, and it's not the most stunning read, I'll tell you. So it's important that you don't need to know the fine detail of the rules any more than you need to know the fine detail of the Act. You know, remember, you're not lawyers. You know, none of us are lawyers. You know, you don't need to know all of that. So don't be terrified and think, oh my goodness, you know, what are they giving us? You know. Yes, hearings have got to be conducted in compliance with the rules, but panel training will enable you to meet those requirements. We will make sure that your training enables you to meet those requirements. So, and the step-by-step procedures that I've already mentioned, we've got step-by-step procedures for a pre-hearing panel and for hearings. They will encompass all those requirements, and provided you do that, you'll be compliant.